Before I go to the main text of this address, I will like to create your indulgence to let the world know that we are grieved by the state of things in our dear country. Miscarriage of justice is fast becoming norms of our Nigeria today. And this is unthinkable that anyone will not mourn. The entire country is mourning. We are mourning. I weep for my dear country, Nigeria. Gentlemen of the press, National Working Committee of our great party, after a thorough examination of all the issues relating to the miscarriage of justice by the Supreme Court on the IMO State governorship election petition, and after a very extensive consultation, resolves as follows: that the Supreme Court, as presently constituted under Justice Mohammed Tanko, has become heavily compromised, lost its credibility, and now annexed to execute ignorable agenda of the APC-led federal government against the people of Nigeria. That the judgment of the Supreme Court voiding the lawful election of Honorable Emeka Ihedioha, who scored 276,404 and awarding fictitious votes to declare Hope Uzodinma of the APC, who scored 96,458 as a governor of Imo State, is highly irrational, unfounded, a provocative product of executive manipulation, and a recipe for crisis, which we don't pray for, which should not be allowed to stand. With the verdict of the Supreme Court executed, a coup against the PDP and the people of Imo State, as well as other Nigerians, and as such must not be allowed to have a place in our democracy. The questions Justice Tanko's Supreme Court must answer are: 1. The Supreme Court, in a host of cases, the latest and most celebrated being Atiku versus Buhari and Co., consistently decided that for a petitioner to succeed in an allegation of infraction of any provision of the Electoral Act, especially one complaining about malpractices, as in this case, wrongful exclusion of votes, the petitioner must call witnesses polling unit by polling unit. The question is, how many witnesses did Uzodinma APC call for the 388 polling units from where the Supreme Court allocated votes to him? The so-called results from the 388 polling units were rightfully rejected in line with several decisions of the Supreme Court. by the Tribunal and Court of Appeal, as it was merely dumped on the Tribunal in a Ghana must go back by a policeman who had no mandate of the police to testify at the Tribunal. The Tribunal did not even open the Ghana must go back, as there was no basis to do so. It is one of the greatest wonders of the world how the Supreme Court opened the bag, counted the result, and added them to only the APC candidates. What is more perplexing is the fact that INEC produced a schedule of reasons why results were not produced from the 388 units. Indeed, election did not even take place in most of the units for one reason or the other, like violence, etc., etc. And so no result could possibly be obtained from those units. No, the results were not merely rejected or cancelled by INEC. None of the candidates or their counsel, except perhaps APC, as we speak, are aware of the number of votes scored by each party from the 388 polling units. The Tribunal or Court of Appeal did not mention or ascribe any figure from the unit to any party in their decisions. In fact, in the cross-examination of the APC candidate, Senator Hope Uzodinma, he could not read any figure from the Oluwale results. He said that the figures were not clear. And so it beats our imagination where the Supreme Court conjured and manufactured the figure it used in declaring Uzodinma APC as duly elected. But the law is settled as decided by the Supreme Court in Buhari versus INEC in 2008 that weight can hardly be attached to a document tendered in evidence by a witness who cannot or who is not in a position to answer questions on the document. One of such persons, the law identified as the one who did not make the document. Such a person is adjudged in the eyes of the law as ignorant of the content of the document. 2, does the Supreme Court have powers to formulate and allocate votes as election results? This is the question. 3, where the said results satisfied by INEC as required by law? 4, did Hope Uzodinma call the 388 witnesses from the 388 polling units to speak to the result to obviate the principle of dumping which the Supreme Court had used against the PDP and our candidate, Atiku Abubakar, in the last presidential appeal? 5, where the presiding officers and all party agents of the 388 polling units called to testify by Uzodinma APC, who were the petitioners. 6, what are the figures from each of these various 388 polling units generated and allocated to Hope Uzodinma APC by the Supreme Court? 7, is the Supreme Court saying that all the votes from the alleged 388 polling units were for the APC alone, in an election that was contested by over 70 candidates. 8. It is on record that the vote analysis from the IMO governorship election as at March 11, 2019, when the results were declared, were as follows. Total accredited votes, 823,743. Total valid votes, 739,485 votes. Council votes, 25,130. Total valid votes, 714,355. But at the Supreme Court, the total valid vote have increased to 950,952. And this can be cross-checked. This accounts for 127,209 votes in excess of a total accredited votes of 823,743. The question again is, can the Supreme Court sit in Abuja on January 15, 2020 to increase the total number of accredited votes in the election held in IMO on March 9, 2019? Is there any law which permits the Supreme Court or anyone else, for that matter, to unilaterally increase the total accredited votes by any margin after the accreditation and or the election? 9. Where did the Supreme Court get the numbers to declare Hope Uzodinma APC from a paltry 96,456 votes over Ihedioha PDP votes of 276,404. Even if all the excess accredited votes of 127,209 manufactured by the Supreme Court were added to Uzodinma APC, it would be still 223,657, still less than Ihedioha's vote of 276,494 by 42,747 votes. 10. The victory of Ihedioha PDP were confirmed by 2 concurrent judgments of both the Tribunal and the Court of Appeal. And in the tradition is that the Supreme Court hardly tamper with such decision except it was found to be perverse. What was the evidence of the perversity? It is important to also bring to the consciousness of well-meaning members of the public, especially the press, particularly Nigerians, that there were 2 elections in March, on March 9, 2019, namely governorship and the House of Assembly. As already known, there was only one accreditation for the 2 elections. The APC did not win any of the 27 seats in the Imo State House of Assembly, which were won as follows. PDP won 13 seats. AA won 8. ABDA won 6. APC 0. Total 27. The above further question and confront the rationale for the judgment of the Supreme Court on Imo State. How then did the Supreme Court arrive at its decision to allocate results to void a lawful governorship election and impose an unelected person as a governor? The fact is that the Supreme Court, as presently constituted under Justice Tanko, has lost its credibility and no longer commands the respect and confidence of Nigerians. If the people no longer reimpose confidence in the Supreme Court, then our democracy, national cohesion, and stability are at a great risk. The constitution of the panel that had the appeal itself was a product of drama. The panel was changed 3 times, and any judge that shows signs of not agreeing to modern democracy, in this case, was promptly removed by the CJN. The result had to be ominous to satisfy the script of rationality. But can any judge who sat on that panel go home and sleep well? Can any judge who sat on that panel face his creator and swear that impartial justice was done? We think not. We had intelligence before the verdict on the IMO governorship that the hierarchy of APC had decided that they must use the Supreme Court to capture the states won and controlled by the PDP, such as Imo, Sokoto, Bauchi, Adamawa, and Benue. Can the PDP rightly trust the impartiality and independence of the panel headed by Justice Tanko Mohammed, the CJN, to adjudicate on the remaining cases involving the PDP, like Kano, Sokoto, Benue, Bauchi, Adamawa, and Plateau, and others? Is the same fate awaiting the governors of these states that are controlled by the PDP and other states like Kano, where the PDP clearly won and was wrong? Should Justice Tanko Mohammed and his colleagues on the IMO governorship panel not rescue themselves from the remaining cases involving PDP? The PDP firmly holds that if the flawed judgment of the Supreme Court on IMO governorship election is allowed to stand, it will be a recipe for anarchy, chaos, and constitutional crisis, not only in IMO, but the entire country. Our party has it in good authority that Justice Tanko and his panel are working on instruction from certain forces in the presidency to use the Supreme Court to take over states lawfully won by the PDP and award them to APC. The PDP, therefore, advises Justice Tanko not to allow himself to be used to push our nation to the path of anarchy and constitutional crisis, as any further attempt to subvert the justice in the pending petitions in Sokoto, Bauchi, Benue, Adamawa, as well as Kano and Plateau states, will be firmly and vehemently resisted. The country belongs to all. There is no person that is super or more Nigerians than the others. The truth must be told. In order to avoid an imminent breakdown of law and order, which we seek, the PDP demands that Justice Tanko Mohammed immediately step down as CJN and chairman of the National Judicial Council, as Nigerians have lost confidence in him and a Supreme Court under his leadership. Justice Tanko must not head the panel to determine the remaining election petition before the Supreme Court. A final issue to be noted is that it is in the public record that Justice Kudarat Teterepu Okon has been the consistent instrument used by anti-democratic agents resident in Lagos, from where she was elevated to the bench of the Supreme Court to deliver at last 3 of the most doubtful and controversial judgments, which removed PDP governors and other elected officials. These judgments are: 1. Paul Ugbo versus Lei Imoke, where Lei Imoke was removed in a very suspicious circumstances in 2007 when she was at the Court of Appeal. 2. Adeleke versus Ayatollah, delivered in 2019, which annulled the election of Adeleke by the Osun people. And now, 3. Uzodinma versus Ihedioha, delivered on January 15, 2020, which removed Ihedioha of the PDP, who won the election with 276 votes, 494 votes, and replaced with Uzodinma of the APC, who came fourth in the election with a party number 96,458 votes. These cannot be mere coincidences. In conclusion, gentlemen of the press, in the light of extraordinary circumstances that vitiate that judgment as a product, manipulation, and a clear coup d'etat against the will of the people of IMO State, we demand that the decision of the Supreme Court on the IMO governorship election be reviewed and reversed in the interest of justice. Furthermore, we demand that Justice Tanko Mohammed, the CJN, and his colleagues on the IMO governorship panel rescue themselves from the remaining cases involving PDP in the Supreme Court. Finally, we state for the records that the Supreme Court order under Justice Tanko Mohammed should be held responsible if there is any breakdown of law and order in any state as a result of judgment procured solely for political rather judicial reasons, as is currently happening. Gentlemen of the press, we wish all of you well, but you are aware that we are in deep sorrow. The country is in pain. Our people are in pain. And we weep for our country, Nigeria. Thank you, and God bless all of you.